Good morning, I'm Fundo Mabalano. You're watching Newslink on DSTV channel 403. We start with this. Another blow for the Public Protector. The Western Cape High Court has dismissed her application to stop impeachment processes. This comes after the President suspended her yesterday. Let's get reaction now. Joining us is Cathleen Powell from UCT's Public Law Department. Ms. Powell, good morning and thank you very much for your time. Yet another blow indeed. Your reaction firstly to that judgment dismissing her application.
I did not catch the reasoning given, and from what I did catch, I understand the reasons might still be provided. So I can't speak on the process of logic of the court, but from what I saw, from the arguments and from the whole process so far, it looked like a no-brainer. It looked like a case that the Public Protector had to lose because she had no basis in law to get what she was asking for. So I'm not surprised. I'm glad of the personal cost order because it might stop the Public Protector from continuing just to litigate every point, even if it's not valid in law.
I just listened now to the judge in closing there where he spoke on the finality of judgments by the Court, that they cannot see a situation now where a rescission somehow turns down or overturns a judgment or its finality in the Court. What is your position on this one? Was it important to state categorically?
Yes, I think it did need to be stated because what was such an obvious point of law has been muddied by former President Zuma's shenanigans when he brought a rescission application for a decision against him that he had not attended on the basis that he had not attended it. The basis of his rescission application was that he hadn't been there when he had refused to be there. That should, to my mind, not even have been heard, but it was heard. There was even a minority judgment saying, yes, well, maybe the order should have been rescinded. And that introduced a level of insecurity to South African law, which does a great disservice to the rule of law. So what happened after that was that the Public Protector climbed on the same bandwagon, and she applied for a rescission for a case where she, in fact, had been there, but claimed, no, they just got it wrong. Now, that's not a rescission. A rescission is when there's some material fact that the court didn't know at the time and therefore made the wrong decision. It's not that they made a decision of law that the Public Protector disagrees with. Anyway, so that rescission was not granted. And then she tried to get the decision not to grant a rescission rescinded. And this is now getting to the point of absolute absurdity. And it is quite important that a court says no. Once you've got a judgment, you've got a judgment, particularly from the Constitutional Court. And we are not going to assume that the rescission process is going to change anything. We're going to carry on the way law usually works. These cases are extraordinarily weak in law. I mean, they are unarguable in law, and they shouldn't be being brought. And I'm glad that the legal process is now carrying on and not being held up.
Now let's turn our focus to that which captured the minds of South Africans yesterday. Much was made of the timing of the suspension. Some argued that the matter was under judicial consideration. There was just a day to go, but the president opted to suspend. It seems his powers have been affirmed in this respect. What was your view initially, even just yesterday?
When the suspension came through yesterday, I saw it as the logical conclusion of a process that started in March already. So, in fact, it started before March, but we had a panel appointed by Parliament, an independent panel, to see whether there was a premier facie case for firing the Public Protector. They produced a 119-page report, very carefully and clearly substantiated, saying there's a strong prima facie case, 3 pages worth of allegations that seem to be plausible. And on the basis of that, Parliament told the President, right, we're doing this process against the Public Protector. Now, that under Section 193 and 194 of the Constitution gives him the power to suspend her while they are sorting out whether she should be fired or not, whether she should keep her job. Now, it's a common practice in any business, any workplace, that if disciplinary charges are brought against an employee and they are serious enough and plausible enough that keeping the person in the job while you work out the final truth could cause further damage, you suspend the person. That's what was done here. So, yes, the timing was made it look more spectacular, but quite frankly, I'm not sure it would have been possible to avoid some kind of bad timing. You know, Arthur Fraser brought ladies' charges. You had the ATM bringing its case. There's something happening all the time. All that Ramaphosa could do, President Ramaphosa, was to go through the Section 193, 194 process. He'd been told that the Parliament is proceeding against her. He gave her a chance to make representations. She made them. He made his decision. She has now been suspended. So I saw it being so close to the Arthur Fraser Farmgate incident. I knew it was going to make more of a splash, but it's actually part of a process that has been going on for months.
Then to the debate around the possible conflict, in as much as the courts have clarified even this, but it is somewhat of a debate in social media. Everybody in South Africa could be talking about it. Now, under South African legal system, the principle of recusal, we all know, is not only concerned with actual bias, but the existence of reasonable apprehension of bias. So for those that would seek to interpret that aspect of recusal, that the apprehension of bias, do you think that there would have been room there to continue this debate around perhaps the president having to be seen to be impartial in the public's eye in this respect, and perhaps seeing him actually relinquishing the power to suspend and giving it to perhaps another institution or the deputy president? Would that have even been plausible?
Well, let's think about it. We have had this argument before, and I do think that's a space where we might want to find more creative solutions in the future for the problems of apprehension of bias. Bear in mind that the president is not a judge here, and the problem is that the public protector's very job is to investigate people in power. So there's constantly going to be the problem that the investigation that she's running is going to impact on maybe not the president, but somebody else in the NA. So it's going to be very hard to find somebody who really doesn't care about the decision that's going to be taken. So from that point of view, merely because there's an investigation against President Ramaphosa might not be a good enough reason to push him off the slate completely. Having said that, remember that it's not the public protector as a person, as a human being. It's not the advocate Busisiwe Mkhwebane who does this investigation. It's her office. So if she is suspended as a human being, as she as the incumbent is no longer able to do the job, the office can continue to do its work. And if the allegations against her, which have been found to be plausible by the independent panel, if those are true, then having her not on the job will mean that the Public Protector's Office will work better, not worse. So I do agree with you that this recusal issue, given that everybody the public protector investigates is likely to congregate around the cabinet or parliament, might need some better solutions over time. But the one that was adopted here, I do not think was a case of bias, or a case of bias that would have to have the president's decision overturned, particularly as he's acting on the report of an independent panel when he evaluates how serious the situation is and how plausible the allegations are. He's not just making it up as he goes along.
But this is now purely an academic conversation. So for those who might seek to tie this in with the former President Jacob Zuma having relinquished the power to appoint a chair of the commission, would you say they're misguided if there were those that seek to link? Because the conversations are going to start on social media now. Everybody gives reaction to a judgment. So for those that might seek now to link this, that perhaps he could have relinquished that power vested or conferred upon him by the Constitution, that he could have relinquished in this respect because President Zuma had to relinquish the power to choose a judge that would chair the State Capture Commission. Would you say they're misguided in trying to link the two?
I can see why they are going to make the two situations look parallel. They're not. But again, the answer is academic. I'm not sure how many people it's going to convince. First of all, President Zuma didn't choose to relinquish that power. He was instructed to relinquish the power in the Nkandla report by the public protector. So he was acting under a legal obligation. He had to hand over the power to make the decision as to who would run the commission to the Chief Justice. He didn't have a choice. President Ramaphosa has not been told by anyone to relinquish the power, not by anybody with a legal power to make him do it. Now, under the Constitution, the president actually has the obligation to exercise every power that is bestowed on him under the Constitution himself. unless there is a reason that he can't. Now, a reason that he can't would be the one in the Nkandla report. But I'm not sure that President Ramaphosa has a reason to get out of this job. I think that is a longer-term discussion about whether changes should be made to the rules to allow the president and other people in power some kind of way out of answering these difficult cases.
Ms. Powell, thank you very much for your time. At least we preempted the conversation that's coming. At least they now have at least this interview to refer to when they start to debate this matter a bit later on today. Thank you very much for your time. That was Professor Cathleen Powell from the University of Cape Town.